Let's try that again. Good morning, good afternoon, good evening to all of our viewers. And welcome to the presentation of the 2021 Johns Hopkins SAIS International Human Rights Law Clinic presentation. This year, our topic is how does the law protect the right to privacy? And the country that we have chosen to study this year is Uruguay. And over the next 2 hours, we will be presenting reports, outcomes of our research, outcomes of our conversations, our interviews, our study of the human rights situation in Uruguay relating to privacy law. Obviously, privacy is a matter of increasing importance to all of us, given that many of our most intimate thoughts, our friendships, our locations, our finances, our grades, our employment histories, all of these things are now stored online and therefore perhaps available to those whom we do not wish to have access to them. And this is obviously a concern everywhere in the world. We've chosen Uruguay as a place to study this issue because Uruguay is a country we thought that would be manageable for us. It would be a country whose concerns about privacy have been reflected in its law, in its legal system. And it is a country also small enough that we thought we would be able to have access to policymakers and to opinion leaders. And to a large degree, we've succeeded. Now, of course, this year we had to conduct our study without visiting the country at issue, which is a tradition of the SAIS Human Rights Law Clinic. We weren't able to visit Uruguay this year. But we are nevertheless enormously grateful to the friends that we've made in Uruguay, government officials, diplomats, academics, scholars, participants in the privacy space who have been very generous with their time, even while Uruguay has been combating the COVID-19 pandemic, which has been especially devastating in that country during this calendar year. And you'll be hearing more about that as we proceed. The students whose presentations you will hear are 12 graduate students at Johns Hopkins SAIS. They are international law and organizations concentrators, that is majors, to those of you not in the SAIS community. And they will be using the knowledge and the skills that they've learned in their study of international human rights law in the presentations that you are about to hear. So without further ado, we will begin by presenting the ground rules, the roadmap of what we have attempted to do before we then delve into the substance that we've discovered with respect to the Oriental Republic of Uruguay. So I now hand the floor to the first of our students to speak, Matt Bauer, who will describe what it is that we attempted to do here, our research design, and we will then go through several of the introductory materials before we then break down into the 4 areas of our specific study. So Matt, over to you.
Thank you for the introduction, Professor Schneebaum. Like Schneebaum said, I will be going through kind of the roadmap of what we're looking into. So we begin with the 3 introductory sections for the purpose of this presentation. It'll be history and context, government of Uruguay, and the introduction to international human rights law. So the idea of it is to give an understanding of what the right to privacy looks in the international community, and then apply that to the Uruguayan context. Next, we'll go through the substantive sections, personal privacy, data privacy, government surveillance, and privacy in the context of COVID-19. So personal privacy is broken down to 3 areas. The first of which is searches and seizures. The second, sexuality, which is further broken down into protection of non-consensual pornography, and the rights of the LGBTQ population, which is further then broken down into same-sex couples and trans individuals. And then lastly, we look at the right to sexual and reproductive health, focusing primarily on abortion. Next, in the data privacy area, we will first underline the legal regime behind data privacy, with special focus on the law 331, the protection of personal data. And then we will look at 3 case studies. The first, tax reforms and financial data. Second, budget law and data privacy. And then third, the digitization of education, and which is interesting with a connection between Uruguay and Google. Third, government surveillance, which is of particular interest given Uruguay's history of military rule. And furthermore, courts have great discretion when it comes to surveillance, and that combined with the evolving technologies of surveillance can have quite serious implications on privacy. This group's presentation will be further broken down into the underlying legal regime behind surveillance, surveillance in public spaces, surveillance in private communications, and El Guardian, a recently bought surveillance technology in Uruguay. And then last but not least, privacy in the context of COVID-19. As we all know and have experienced, COVID impacts all parts of society, and privacy is certainly no exception. We will look into how the pandemic has evolved in Uruguay, the government and legislative response to the pandemic, and finally, a case study of coronavirus UI, an application designed by the Uruguayan government in cohesion with private entities that became a one-stop shop for every news and resources related to the pandemic. And then finally, a brief look into what it means to come out of the pandemic and a state of emergency, where will these possible infringements on privacy to protect citizens against the pandemic continue on into normalcy, or will they be put on the shelf? And so now I'll pass it to Kongdi, who will provide a historical overview of Uruguay.
Hi, I'm Kandi Chan. I will be introducing the history of Uruguay in general. Please, next slide. The full name of Uruguay is the Oriental Republic of Uruguay. It has 3.5 million population, and it is neighbored by Brazil and Argentina. The capital is Montevideo, lying on the southern bank of the seashore of the country. And the formal language is Spanish, because it used to be a Spanish colony in the 16th to the early 18th century. And Uruguay was a former buffer zone to protect Spanish colonies from Portuguese and British invasions. And the geopolitical situation of Uruguay played an important role in shaping its political and legal institutions. Next slide, please. In the early 1800s, as Napoleon waged its war in Spain, the Spanish influence on the new continent began to fade. So in 1816, the Brazilian Empire annexed Uruguay, but they did not hold it long. In 9 years, the Six-Month War began. With Argentina's support of Brazil's feud, Uruguay revolted and won the war and declared its independence. Because both neighbors, Brazil and Argentina, had Western democratic institutions, the separations of powers systems, so did Uruguay. In 1830, Uruguay adopted its very first constitution, which established a bicameral legislature, an executive with strong and centralized power, and an independent judiciary. But there were about 3 decades of political conflicts in the coming years between the major 2 political parties in Uruguay, the liberal Colorados and the conservative Blancos, or the Nationals. And there was even a civil war. The Guerra Grande broke out in the 1850s, which left a very profound political impact on the country, which my colleague Alex Ferraz will introduce in his sections. And in 1872, the conflicts gradually calmed down. Uruguay began to have rapid economic development and received an immigration surge and gradually formed into a modern welfare state. Next slide, please. But the turning point came as the Great Depression began to have its impact on the country. In 1933, there was a military coup d'etat because of the economic unrest. And although democracy returned in 1942 with another coup d'etat, the economic status in the country was still bad. And the deteriorating economic status and instability led to further concentration of administration power. So in 1967, there was a new constitution which granted the executive head with even greater sweeping powers. And the next year, the president declared a state of emergency to quell violence. But that led to the transition to the later authoritarian regime. Next slide, please. A marking point was 1972 when President Bordaberry got elected. He first suspended civil liberties and then the constitution itself and began to share his powers with the military. In 1973 to 1976, he became the head of a civilian and military dictatorship, but also he was eventually ousted by the military in 1976. After that, it was the military government had de facto control of the country. During the 13 years of the military regime from 73 to 85, the military regime had massive human rights violations. They excessively used the state apparatus against their political opponents, and there were more than 200,000 Uruguayans were detained, imprisoned, and tortured for these reasons. And the turning point came in 1980, when the military regime tried to institutionalize their de facto control by a new constitution proposal. It was rejected in the referendum by the public. And that marked an increase in discontent among the public about the military dictatorship. And that gradually led to a compromise between the military government and the democratic politicians in 1984 in the Naval Club Pact, which returned the democratic election and the 67 constitution to the country. Next slide, please. But that did not automatically clean up all the mess. In 1986, even after the democratic government returned, the parliament overwhelmingly passed the amnesty statute, which granted immunity to military and police officials and soldiers who allegedly had committed human rights violations during the military regime. That led to the civil society's opposition. 3 years later, in 1989, finally, the civil society initiated an anti-amnesty referendum trying to revoke the law based by the Constitution. While that referendum sadly failed by a small margin, it had 85% of overall participation rate throughout the country. So while the referendum itself failed, it marked the beginning of reviving civil society who had their attention focused on human rights violations and possible human rights violations in the future. And that left a lasting impact, a vigilant civil society that lasted until today in Uruguay, keeping an eye on human rights and including privacy issues we're discussing today. And now let us welcome my colleague, Alex Ferraz, to introduce the government structure of Uruguay.
Thank you so much, Kangbi. I'm going to be introducing Uruguay's government structure. So the executive branch is led by the President of the Republic, who serves as both head of state and head of government. The president is given command over all armed forces and responsibility over foreign affairs. The president also possesses the ability to propose a general annual budget to the General Assembly and may propose or veto legislation in both the upper and lower chambers. The president and the vice president are both elected for one 5-year term. Since 1999, Uruguay actually elects its presidents through a 2-round system. In round 1, the primaries, each party selects a single candidate to represent it in the national election, whereas in round 2, the general election, the candidate with the majority of the votes wins the presidency. And if no candidate wins a majority, there is a runoff between the 2 candidates with the most votes. And of course, the candidate with the majority there is elected president. The current president is Luis Lacalpo, a member of the centrist right National Party. He took office on March 1st, 2020, after a national runoff with the Broad Front candidate in November of 2019. So for the legislative branch, the Uruguayan legislative branch features a 130-member General Assembly composed of the Chamber of Senators and the Chamber of Representatives. The Senate comprises 30 members elected through national elections, whereas the Chamber of Representatives are elected by the residents of their respective national subdivisions. Both senators and representatives are elected to 5-year terms and are not subject to term limits. As per Article 133 of the Uruguayan Constitution, bills may originate in either chamber or in the office of the president. If a bill is approved in the chamber in which it originated, it is sent to the other chamber for approval. If the two chambers cannot agree on a bill, the chamber in which the bill originated can convene a joint session to draft the new law. The content of the bill is then decided by a 2/3 vote, which is also subject to modification of the divergent bill or even just approve a new one altogether. After the two chambers agree on the content of the bill, it goes to the president, who may either sign it into law, request changes, or reject it. If the bill is returned to the legislature by the president with proposed changes, a 3/5 supermajority of each chamber of the General Assembly must accept the proposed changes before it becomes law. Similarly, if the executive vetoes a bill, the General Assembly may, by a 3/5 supermajority in both houses, override the objection as per Article 138 of the Constitution. And Article 85 of the Constitution lists the 20 powers afforded to the General Assembly. In addition to enacting laws, the Assembly may impose taxes, appropriate funds, approve or reject treaties made by the executive, create and abolish new government offices, departments, and monopolies, establish tribunals and regulate courts, elect members of national courts and tribunals, and enter armed conflict. And for the judicial branch, there are 5 institutions: the Supreme Court of Justice, the Courts of Appeal, district courts, peace courts, and rural courts. Uruguay's judicial branch functions under national authority independently from the other 2 government branches. Each court operates under the administrative authority of the Supreme Court of Justice. The Supreme Court is made up of 5 justices nominated by the president and approved by the General Assembly with a 2/3 vote. Judicial terms run for 10 years, with re-election allowed 5 or more years after the previous term, or reappointment, I should say. The Courts of Appeal hear appeals against initial decisions handed down by district courts. They are subdivided in turn into civil, family, labor, and criminal units, and hear cases in panels of 3 judges. Appellate judges are also appointed by the Supreme Court of Justice and approved by the Senate. Finally, district courts are divided into 2 types: district courts of first instance for the capital city area of Montevideo, and district courts of first instance in the interior for areas outside Montevideo. District courts also act as appellate courts for peace courts. They hear cases in specialized tribunals for criminal, civil, labor, customs, juvenile, family, contentious administrative, and bankruptcy matters. Rural courts hear civil, commercial, and finance claims not exceeding 120,000 Uruguayan pesos in areas not corresponding to municipal districts. Next slide, please. So there are 3 principal political parties in Uruguay. The National Party, which is the Partido Nacional in Spanish, also known as the Blanco Party, or PN, is the center-right political party and one of Uruguay's oldest establishment fronts, along with the Colorado Party. The party was founded on August 10th, 1836, and the ideology blends Christian democracy, liberal economics, and social conservatism. The National Party is mostly supported by higher income citizens, clergy, the military, and rural landowners. And like its chief rival, the Colorado Party, the Blanco Party possesses its own internal factions called sublemas. The Herrerist movement, or Movimiento Herrerista, is the largest, named after founder Luis Alberto de Herrera, whose grandson Luis Alberto Lacalle and great-grandson Luis Alberto Lacalle Po both went on to serve as president of Uruguay. Of course, the latter is the current president. And actually, although the National and Colorado parties dominated Uruguayan politics throughout the 19th and 20th centuries, the former only recently regained power following the 2019 elections, where Blanco Party candidates won the presidency as well as General Assembly majorities. In addition to the presidency, the National Party also holds 30 of the 100 seats in the Chamber of Representatives, 10 out of 30 Senate seats, and 90 out of 112 mayoral seats. The Colorado Party, their slogan is that it believes in a system of law based on an individual freedom, social justice, and popular sovereignty. Today, the party is linked to labor unions, secularism, and progressive movements. Generally, it is seen as the more liberal or left-leaning political thought party. The party acts as a spectrum attempting to capture left-leaning moderates to more progressive voters. And of course, like the National Party, the Colorado Party also has a number of sub-parties or sublemas acting as individual factions under the party umbrella. The Colorado Party held executive power from 1865 to 1959, then again from 1967 to 76. Their most famous president was probably Juan Bordaberry, as Kangbi introduced, who was widely credited with installing the military dictatorship. Over the last 20 years, however, the Colorados have only won the presidency once, with George Bataille filling the executive position from 2000 to 2005. And in both chambers, the third party, also serving as the current opposition, is the Broad Front, which is a more leftist group that rose to prominence in the early 21st century. The Broad Front, Frente Amplio in Spanish, was created by communists, Christian Democrats, and progressive leaders who defected from the Colorado and national parties. And importantly, the Broad Front is a bit different from the other two parties in that it relied and continues to rely more on grassroots organization and bottom-up decision-making, which enabled it to adapt to local concerns on a unique scale, unlike the other parties. In its early years, the Broad Front struggled to garner support from the Uruguayan Republic. It received only 1/5 of the vote in 1971. And in the 1970s and 1980s, the Broad Front was heavily repressed by the military dictatorship, which feared its more leftist political ideology. The party was seen as a crucial component of the nation's clandestine struggle, an image which enabled its leaders to play a key role in Uruguay's reconstruction efforts. Voters did reward the Broad Front for essentially its standing up to the regime. By 1994, the party secured 31% of the national vote before winning national elections in 2000. And then two Broad Front leaders in particular, Tabaré Vázquez and José Mujica, won 3 successive presidential elections between 2005 and 2015, which was very much emblematic of the pink tide of leftist leaders in Latin America at the time. They were able to deliver enduring economic growth, reduction in poverty and inequality, and a high investment grade status. And that's it for my section. I'm going to turn it over to Ashley.
Yes, thank you, Alex. I will now provide a quick overview of international and regional human rights law. So quickly, what is international human rights law and why is it relevant? First, it comprises of treaties, which are legally binding agreements among states parties, so countries, and customary international law, or rules derived from the consistent practice of states that are then accepted as legal obligations. Other instruments like declarations, guidelines, principles, and decisions of tribunals adopted at the international level are also a part of the corpus of international law. By adopting international law into domestic statutes, governments like that of Uruguay provide the mechanisms to enforce the international legal standards to which they have committed. So which human rights treaties form the core of international human rights law and that Uruguay has ratified and adopted into its domestic laws? The first, though not binding, is the Universal Declaration of Human Rights, a milestone document that outlines the basic civil, cultural, economic, political, and social rights for all humans across the world. It was adopted in 1948 by the General Assembly, and its principles have formed the nucleus of the main human rights treaties, such as the ICCPR, or the International Covenant on Civil and Political Rights, adopted in 1966. This treaty ensures the protection of individuals' rights vis-a-vis their own governments and commits states parties, among other things, to freedom from torture and other cruel, inhuman, or degrading treatment or punishment, fair trial rights, freedom of thought, religion, and expression, respect for privacy, home, and family life, and equality and non-discrimination before the law. The ICESER, or the International Covenant on Economic, Social, and Cultural Rights, is another core treaty under which states must take steps to respect, protect, fulfill, seek, and provide international assistance in relation to the rights listed within the covenant. Other core treaties include the Convention on the Elimination of All Forms of Discrimination Against Women, the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, and the Convention on the Rights of the Child. Regionally, Uruguay is recognized as a leader in signaling a commitment to the domestic implementation of international human rights law. Uruguay is a party to all of the core human rights conventions and has ratified or accepted all of their respective optional protocols, indicating an intention to integrate the principles and obligations of international human rights law into its domestic legal system. Next slide, please. The regional human rights law system includes the American Human Rights Convention, the Inter-American Commission on Human Rights, and the Inter-American Court of Human Rights. As of 2018, Uruguay was the only member of the Organization of American States, or the OAS, to ratify every one of the binding legal instruments of the Inter-American system. Uruguay is an original member of the OAS, which was founded in 1948. Member states then enshrined for its citizens fundamental rights like the right to life, liberty, personal security, and equality before the law. The 23 OAS member states also ratified the American Convention on Human Rights in 1978, also known as the Pact of San Jose, Costa Rica, to create the Inter-American Court of Human Rights, which functions as a regional court with binding jurisdiction, as well as a legal advisory body. This convention enshrines the rights to privacy, freedom of movement, and freedom of expression within the region. Since then, these rights have been expanded to include the right to be free from discrimination based on age, gender, or disability, as well as the rights to health, work, and participation in culture. Other rights include that to seek, receive, and disseminate information and opinions freely, and the right of access to information about oneself in a reasonably accommodating manner. When individuals in an OAS state believe that their human rights have been violated and that no remedy may be obtained through their domestic judicial process, they may lodge complaints with the Commission for referral to the court. The Commission then reviews these complaints and recommends that the court receive cases in which serious breaches of human rights have occurred. Next slide, please. International laws also protect the right to privacy, which is the main focus of our report. This encompasses regulating government searches, surveillance, and the regulation of electronic data. The right to privacy was first affirmed in the Universal Declaration, stating, as you can see here, that no one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honor and reputation. Everyone has the right to the protection of the law against such interference or attacks. This affirmation has since been enshrined in the ICCPR, the ICE, SCR, and its optional protocol, and the Convention on the Rights of the Child. As for the regional human rights system, regional laws guarantee the right to privacy of citizens of OAS states to the same standard as the Universal Declaration and the ICCPR, and their institutions have provided elaborate explanations of the contours of that right. Uruguay, as an OAS member state, is obliged to honor the right to privacy of its citizens as set out in the convention and as explained by the Commission and the court, without any discrimination for reasons of race, color, sex, language, religion, political or other opinion, national or social origin, economic status, birth, or any other social condition. To date, the Inter-American Court of Human Rights has never found the government of Uruguay to have violated its legal obligations to uphold and protect the privacy of its citizens. So that's a brief introduction into human rights laws and the right to privacy. And that leads us into the first of our 4 substantive sections, where Ricky, Isaac, and Rushu will expand on how this right has been enforced with respect to personal privacy.
All right. Hello, everyone. I'm Isaac, and sorry. And I'll kick off the personal privacy section. So in personal privacy, we're going to start by talking about searches and seizures, mostly focusing on recent changes to the Uruguayan criminal code. Then later on, Rushu will talk with us about issues under sexuality and privacy. And then finally, Ricky's gonna finish us out here with rights related to sexual and reproductive health. So next slide. So the first thing that we're gonna talk about is issues related to Uruguayan criminal proceedings, specifically searches and seizures. Now, when we began researching the issue of searches and seizures and personal privacy in Uruguay, the first thing that's immediately clear is that there are robust protections for Uruguayan homes and Uruguayan correspondence that exist at the constitutional level. However, when it comes to the Uruguayan criminal justice system and the Uruguayan statute law, these protections are still robust. However, they're also, the statute laws were recently heavily revised. And a lot of these new laws, the court system has not had the chance to road test them yet. and the court system itself has also recently been heavily reformed. So for that reason, when it came to searches and seizures, we chose to rather than focus on current issues, which wouldn't really make sense because of the newness of the statute laws and the systems, but we kind of touch on the major changes that had happened here. Now, the first and most important change to be aware of in Uruguay is they have shifted from an inquisitorial criminal justice procedure to an adversarial one. What this means for searches and seizures, under the old inquisitorial system, the investigation was led by a judge and then tried by the same judge. So under the old system, you would have had a scenario which a judge would have ordered a search to be conducted. And then when the judge conducted the trial, the judge would be assessing the evidence they themselves had already collected for admissibility in their court, which has a natural conflict of interest to it. Under the new system that has been implemented, it's an adversarial system, but the important change in context of the searches and seizures is now the public prosecutor directs the investigation. So what happens now is the public prosecutor will direct the police to conduct a search, and then during the trial phase, the judge will not have been involved with that investigation, and now the judge will review the prosecutor's work to determine whether or not the searches were lawful and whether or not the evidence garnered from them are admissible in court. And that's really going to reinforce the independence of the Uruguayan judiciary. Now, we have also been seeing updates in police procedure that we also think are going to help ensure that Uruguay's robust statute laws are properly followed and enforced. The first and most important is the Ministry of the Interior has been pushing forward a new body camera program. And the important thing here is that will give the judge another source of information on judging whether or not searches are being properly conducted besides the officer's own written reports. So that's going to be a very helpful tool for the judges when they look at admissibility. And the other thing that the other reform the Ministry of Interior has been pushing is they have been working hard to make complaint reporting to the police a lot easier, which will again, which is again going to help increase the police accountability and make sure that the proper search procedures are being utilized, especially in a street context, where a warrant may not be justified if an officer has probable cause to believe a crime is being reported. In these instances, the public having an easier access to complaints will enhance the robustness of the system. So that's everything we have on searches and seizures. Now Rushu is going to take us through sexuality and privacy.
Thank you, Isaac. The first issue I'm going to talk about on sexual conduct and privacy in Uruguay is protection for victims of non-consensual pornography. For general pornography, it's legal to possess that in Uruguay. However, it is illegal to distribute it, especially non-consensual pornography, which is also referred as revenge porn. For non-consensual pornography, Uruguay has taken steps to criminalize that 6 years ago. Revenge pornography bill was enacted in 2015 to criminalize the spread of intimate images of recognizable individuals without their permission and punish social platforms that fail to remove such content from their websites. Later on, in 2018, Uruguay extended protection to citizens against the distribution of their intimate images or recordings with private content without consent through Article 92 of Law Number 19580. Besides that, revenge porn cases have been judicially reviewed according to Criminal Code Article 335 and 278, treating the offense as slander and pornographic exposure. They both set a penalty of a fine or 3 to 24 months in prison. However, if a person in images or recording is under 18 years old, no matter his or her consent, distribution of their intimate content violates the law and will be criminalized accordingly. Next slide, please. The second issue in sexuality and privacy is the right of same-sex couples. Uruguay is one of the 28 countries in the world that recognize same-sex couples. Article 10 of the Constitution protects the private action of persons which do not in any way affect public order or others, and this includes private, non-commercial sexual activity between adults under consent. The protection of the rights of sexual minorities in Uruguay has been dynamic since 2003, when Uruguay revised its penal code to prohibit acts of hate, contempt, and physical or moral violence on other sexual orientation or identity. Article 149 bis of the penal code punish actions that incite hatred due to sexual orientation or gender identity. Following on that, in 2004, Uruguay adopted law number 17817 on the fight against racism, xenophobia, and all other forms of discrimination. The law protects people against discrimination based on gender, sexual orientation, and identity. Besides eliminating discrimination towards sexual minority, Uruguay also destigmatized homosexuality in the military and non-military contexts. In 2009, Uruguay declined the 1973 listing of homosexuality as among the mental illness and disorder constituting unsuitable conditions for service in the military. 8 years later, in 2017, Article 4 of the Mental Health Law number 192,529 extended this to non-military contexts, providing that in no case may a diagnosis be established in the field of mental health on the exclusive basis of sexual orientation and gender identity. With all the efforts on eliminating discriminations and stigma on homosexuality, Uruguay legally recognized same-sex couples since 2008 through the decree of law number 18246 and law number 18590 on childhood and adolescence. Article 139 of law number 18590 allows civil union couples, including same-sex couples, to adopt children. To obtain recognition of a civil union, the couple must be in the relationship for at least 5 years without interruption, and they must submit a request for recognition to a court. After the recognition is granted, the couple has the same rights and obligations as a married couple. In 2013, law number 19075 on equal marriage provided even more progressive recognition to same-sex couples. This law recognized that civil marriage is a permanent unit under the law of two persons of the opposite or same sex. This provides the equal marriage law replace a number of articles under the civil code that previously limit marriages to partners of opposite sex. The efforts of Uruguay has made on protecting the right of same-sex couples is progressive. Uruguay is the first Latin American country that recognized same-sex civil unions at national level, and the second country in Latin America that passed a national law on same-sex marriage. Now let's welcome my colleague Ricky to talk about the rights of transgender and abortion.
Thank you, Aurora. The third issue in the rights of sexual minorities is the rights of trans individuals. The protection of the rights of trans individuals in Uruguay has been progressive since 2009, when Uruguay first enacted a law that enabled trans persons to change their name and sex in public documents. And within a decade, Uruguay has passed a new law, law number 19684 of the Comprehensive Law for Trans Individuals. This new law extends first the recognition of the right to identity of trans individuals. Second, it also provides a remedy mechanisms for trans persons who suffered from the military dictatorship. And third, the law also mandates affirmative actions by allocating slots specifically for trans individuals, such as 1% of the governmental jobs, 1% of seats at training programs, and 2% of the scholarship recipients from public institutions. Therefore, we are encouraged to conclude that the protection to trans individuals as extended by Uruguay has exceeded the standards of protection as established by international human rights conventions. International human rights conventions do not specifically mention trans and other LGBTI persons as right holders. Instead, they only require states to protect rights and freedoms of everyone, regardless of their sex. And the specification of LGBTI persons as right holders is only generally incorporated in UN General Comments. And for the way forward, we perceive that in order to fully implement the law, There are other measures that Uruguay might pursue. One of them is other ministries might follow the steps taken by Ministry of Social Development to integrate trans individuals into their program, also to include trans men and trans women as gender classifications in various documents and statistics. Next slide, please. The last issue in personal privacy section is the right of sexual and reproductive health, especially abortion. And the laws related to abortion have been very dynamic in Uruguay ever since 1934. In 1934 until 1938, Uruguay had allowed abortion. Then in 1938 until 2012, Uruguay criminalized abortion. But since 2012, Uruguay enacting a law 18897, and by this law, Uruguay decriminalizes abortion. This new law establishes first the criteria and time frame of abortion. Abortion is not allowed for any reasons within the first 12 weeks of pregnancy, and beyond 12 weeks when the pregnancy poses a serious health risk to the mother and also for the baby's life after birth. But in cases of rape or incest, the abortion may be obtained within the first 14 weeks of pregnancy. Before abortion, a woman must undergo a consultation with a gynecologist and also with an interdisciplinary team to receive information about alternatives and also about the risk of abortion. And after the consultations, a woman must wait 5 days before undergoing the abortion. This new law also extends protection for the rights of the doctors to express consensus objection, or CO, when the doctors do not want to be involved in the abortion procedures. But if the doctors do not articulate such an objection, they must not refuse to provide the abortion services. And we feel this law is really significant for women's rights. First, because it decriminalizes abortion. Therefore, it eliminates women's fear of being penalized by law, even after they have suffered physical and mental pain due to abortion. Moreover, since the law also obliges that the procedure free of charge, abortion is then accessible to all women who need the abortion procedure regardless of their financial situation. Next slide, please. However, there is a legal intersections between the rights to abortion on one hand and also to the consensus objection on the other hand. In Alonso case submitted 2015 to the Uruguay Supreme Court of Justice, a group of gynecologists challenged the limitations on CO as established by Decree number 375/2012, especially Article 12 and Article 28. The doctors claim that the articles infringe their freedom of thought in abortion procedures. The court, the Supreme Court of Justice of Uruguay, they approved the claim and then annul the related articles in the decree. So therefore, it is now legal for the doctors to express religious, moral, philosophical opinions to all stages in the abortion process, from the consultation, from the operation, and also for the post-abortion care. We perceive that this issue, there might be an issue that possibly arise with this consensus objection and abortion, because if more doctors express CO, therefore women will travel farther to find doctors who are willing to perform abortion, and therefore their health might be compromised. There is an example for other countries' case, Mellett versus Ireland, which was submitted to the UN Human Rights Committee in 2013. With abortion illegal in Ireland, Amanda Mellett, who is to terminate her pregnancy because it poses serious health to the fetus, she traveled abroad to obtain the abortion despite her limited financial resources. After post-abortion, she came back to Ireland, but she received no care at Irish hospital because there is no services available in Ireland. Therefore, the committee ruled that this was not only cruel, inhuman, and degrading treatment, but it also reflects an undue interference to Mellett's private life. And it also constitutes a violation of her privacy rights as defined in Article 17 of the ICCPR. Therefore, we perceive that in Uruguay or elsewhere, this abortion issue is really a complex one. It is bound tightly to women's rights, both the right to privacy and also the right to sexual and reproductive health. And moreover, the issue of abortion also raises questions of the freedom of thought of the doctors and how to balance this CO with the right to abortion. Therefore, we perceive that the role of governments is really critical in protecting and balancing the exercise of both rights. That's all from the privacy section. We now give the floor to our colleagues in data privacy section.
All right, thank you, Ricky. So now we'll be moving on to the data privacy section of our presentation. And so thus far, we've given a brief intro into the right to privacy as enshrined under international law, as well as how those rights are interpreted and implemented within Uruguay. However, as far as data privacy goes, I think it's important to note that data protection was not even an issue in the international legal sphere as recently as a few decades ago. And since the rise of the internet, we've seen an unprecedented level of digitization in all aspects of life, regarding areas such as citizen info, medical, financial data records, even digitization of government services. And not to put too fine a point on it, but the fact that we're even able to give this presentation virtually in the middle of a pandemic is an excellent example of how the internet has fundamentally changed our lives. So with that power in mind, how do we deal with it? What are the new legal frameworks bringing the right to privacy into the 21st century, ensuring that data is collected and used ethically at an international level? And how has Uruguay adapted those provisions into their own law? Those are the questions that we examined in the data privacy section. And internationally speaking, the first data privacy regime was found in the EU in the European human rights system. While they initially only protected privacy under the traditional interpretation, they eventually expanded their protections to certain elements of data protections. And another major data privacy regime can be found in the Inter-American Human Rights System, which Uruguay is obviously a member of, where protections against unauthorized monitoring expanded into the digital sphere as technology advanced. And last, the most important and robust international data privacy regime is the General Data Protection Regulation, or GDPR. Adopted in 2016, the GDPR represents the culmination of the previous international legal frameworks regarding data privacy and places stringent restraints on how companies can collect and process consumer data. It also mandates compliance with these regulations in order to do business in the EU or use EU consumer data, which is why these protections are relevant for other countries around the world. And domestically, the data privacy regime is principally governed by Law 18331 of 2008, which provides base guidance for the protection and secure processing of all public and private data in Uruguay. The law also provides for the governance of AGISIC and the URCDP, AGISIC, which streamlines the provision of digital government services, and URCDP, which serves a quasi-legal oversight body through which the government can implement the protections of Law 18331. And it's important to note here that Uruguay was one of the first countries in Latin America to enact such sweeping data privacy regulations. And they've definitely carried that reputation forward in the 13 years since passing that law by continuing to prioritize data protection of citizen data. So now we've introduced the international and domestic legal frameworks for data privacy, and we'll now go through 3 case studies on data privacy protections within Uruguay. The first deals with financial data and the history of tax reform, the second with the budget law legislative process, and the third with the digitization of education data. So next slide, please. Our first case study examines financial data protection in Uruguay and looks at the history of tax reforms to see how the power of the tax authority has grown in relation to those protections. So in 2007, Uruguay passed the Tax Reform Act, which instituted the first income tax in the history of Uruguay. So prior to this act, the GGI, the tax authority, mainly focused on auditing corporate entities for the lion's share of their tax revenue. But after this act, as you might imagine, the GGI had to switch gears and utilize the same 1,300 staff that they had on staff to audit millions of taxpayers rather than just 10,000 corporations. So they had to, deter income tax evasion. And this act raised the previous fine limits by up to 1,000 times, up to the discretion of the DGI, based on severity. And it's important to note here that severity is not really well quantified in the language of the statute. It's left largely up to the discretion of the DGI. Then in 2011, Law 18996 further increased the power of the DGI by exempting them from protections found in Law 18331 and allowing them to undertake investigative actions, known as audits basically, which according to some Uruguayan activists, these investigations can take an average of up to 4 years, during which the DGI can freeze assets with impunity. And then last, in 2017, the Uruguayan government harmonized their financial reporting standards with that of international standards, focusing on the elimination of terrorist financing and money laundering. And in doing so, they allowed the DGI to essentially waive the right to a court order in order to access previously protected financial data, so bank account balances. And it's worth noting here, I think, that at the time that Uruguay changed their standards, according to a 2017 Basel Institute on Governments report, Uruguay was ranked outside the top 100 states most at risk for terrorist financing and money laundering. So what's the upshot? First, the DGI has gained a near unlimited discretion in investigation and enforcement of fines. And second, the DGI has chosen to remedy a relatively rare issue in terrorist financing and money laundering by weakening financial data protections across the board for all Uruguayans. And the point obviously is not that the DGI is overstepping in any way or that they should not attempt to deter tax evasion or terrorist financing, but rather that the statutes as written leave the door open for potential abuse if the trend of weakening financial data protections continue. So that's all for me on this case study, and I'll now hand it off to my colleague Ashley to speak on the budget law process.
Thank you, Faraz. Yes, so for our second case study, we looked at how the budget law process has been used to advance the executive's data privacy agenda. While the term budget implies fiscal planning and expenditure allocations, budget bills in Uruguay, similar to other parliamentary democracies, have been used to push a range of reforms packaged in a single piece of legislation. The executive proposes to the General Assembly a 5-year national budget within the first 6 months of a new administration, and budgets are typically passed without major tribulations. Key decisions on what goes into the bill, however, are made well in advance of this stage, limiting transparency and access for civil society organizations, or CSOs, to influence reforms concerning data privacy. Moreover, the General Assembly has only 4 months to pass the budget by absolute majority or to reject it, leaving little time for hearing external input. So this case study looks at 2 recent examples of this pattern, one on an audio-visual content blocking measure, and the other on a facial recognition database. So next slide, please. For the first example, a provision in the initial 2020 budget bill sought to permit the Communications Services Regulatory Unit, a government organ, authority to adopt sanctioning measures without a court order to prevent the dissemination of audiovisual content in violation of copyrights. The provision's vague language raised concerns from CSOs over what discretion would be granted to the government and whether it would provide guarantees for users. Concerned CSOs sent a letter to the General Assembly, and representatives from Observacom and Datisok, 2 locally based CSOs, spoke to the Budget Committee of the Senate, objecting to the provision. They explained that disproportionate measures to protect copyrights through content blocking without a court order would conflict with the rights of free expression and information. They cited guidelines and recommendations for the protection of fundamental rights online, specifically the Manila Principles, which state that intermediaries should be shielded from liability for third-party content, and that content must not be restricted without a court order. By the time CSOs had an opportunity to respond to this provision, the budget had already been approved by the lower chamber and had made its way to the Senate, so they had limited access to make their case on why the provision should be withdrawn from the budget. Given those limitations, the legislative branch ultimately compromised with civil society demands and updated the provision's wording to limit oversight only to commercial television broadcasting services over the internet. This more closely aligned with the sector the provision was initially supposed to target. That such a significant reform had been bundled in with the budget in the first place, however, demonstrates a tension between a government that has touted leadership in the digital rights space and CSOs dedicated to holding it accountable for protecting those rights. Next slide, please. Our second example of the facial recognition database was far more contentious. The provision sought to authorize the migration of data from a database formerly managed by the National Civil Identification Directorate onto a larger database for public security purposes. The government had already purchased the automated facial recognition software in February of 2020, but needed legal authorization to use it. The provision was approved by both chambers in its original wording, despite objections from dozens of CSOs who argued that facial recognition software collides with the principles of necessity and proportionality, pillars of human rights that must be satisfied before intrusion into personal privacy is justified. The concept of public security, they further explained, is broad and undefined in the budget law, which does not indicate the limits for public authorities, including police departments, to collect and utilize personal data. CSOs also cited controversies across Europe and the United States. where facial recognition technologies have generated false identifications more frequently for people with darker skin and for women. Biases and possible leaks, whether carried out by hackers or internal security forces using the database for inappropriate purposes, would constitute a major breach of Uruguay's human rights commitments. Lastly, the expansion of the existing surveillance systems in Uruguay would put many more people at risk of being monitored. By 2019, the Ministry of the Interior had 8,433 cameras distributed across 19 departments in the country, in addition to private surveillance devices. And there was no justification for enlarging these systems. Just as with the audiovisual content blocking measure, by the time CSOs had mobilized to raise concerns about this provision, the budget bill containing it had been approved by the lower chamber, so the Senate's Budget Committee was the only viable forum to make their case. CSOs did collaborate with a few senators, including Sylvia Nane of the Broad Front Party, to push for repeal or reformation of the provision. However, these senators were a very small minority, reflecting the pressure to limit reservations on what might be considered niche topics. To conclude, the budget bill has been used to fly data privacy reforms under the radar, and CSOs have repeatedly flagged concerns about this, as we gathered from our interviews with Professor Anna Taduri, the director of DATISOC, and Professor Fabrizio Scorellini, the director of the Latin American Open Data Initiative. Both argued that data privacy measures should be subject to an evaluation process beyond the expedited public hearings held for budget bill provisions. The technical nature of data privacy measures and their potential impacts on human rights further emphasize that sufficient time is needed to have an informed debate that includes all relevant parties. So with that, I will now hand off to Natalie to present our third case study of the data privacy section.
Thanks, Ashley. So we're going to be looking at our final case study, which was an agreement between Plain Seaball and Google in 2015. So technology has played a key role in improving the quality of and the access to education in Uruguay. And a major driver of that success has been Plain Seaball, which is Uruguay's flagship national education initiative. Some of its biggest successes include the provision of laptops to every child upon entry into the public school system, ensuring all schools in Uruguay are connected to the internet, and providing ICT-based after-school activities. And these are all key for preparing young Uruguayans, regardless of socioeconomic background, for the future needs of the labor market. And the achievements of Plain Seaball are even more impressive when they're viewed from a regional perspective. So for example, while Uruguay had achieved 100% public school internet connectivity, just 64% of Chilean students and 32% of Brazilian students had access to the internet through their schools in 2016. And so this case focuses specifically on an agreement between Plain Seaball and Google that caused a bit of controversy back in 2015. But to understand that, it's first important to understand some basic terminology. Next slide, please. So cloud computing refers to the delivery of computing services such as storage, software, and databases over the internet. And Uruguay's use of cloud computing in the educational sphere has grown significantly in recent years. And this growth has simultaneously created opportunity for innovation in teaching methods and pose privacy-related challenges for users. So for example, the ability of such platforms to store and process huge amounts of data as students progress through the educational system facilitates the creation of student-specific profiles that could be used for example, unsolicited targeted advertising. And yeah, in short, there just is a lot of potential for students' data to be used for purposes other than what they agreed to when they make accounts on these educational platforms. And so really quickly, stick with me, there are three main types of cloud computing, and this is important for understanding the controversy. So private cloud systems are generally operated by an individual company, but the servers of private clouds can still be hosted by third parties. And so sensitive information and privacy is generally best protected and controlled in these systems, but it's really not feasible or sustainable for most institutions, including school systems, to use private cloud systems because they're really expensive to operate and manage. The second type is public clouds, which these are the most common type. All the servers and storage of these servers is owned and operated by third-party providers. And even though public clouds have a lot of ways of protecting the privacy of individuals' users' data and preventing its access by other cloud users, it is ultimately still hosted publicly and therefore is potentially more vulnerable to mass exposure or inappropriate usage than if it were stored privately. And finally, hybrid clouds kind of just combine good characteristics from both public cloud systems and private cloud systems. So they provide a way for schools or other institutions to hold particularly sensitive information on private cloud servers while allowing less sensitive information to be hosted on public servers. However, again, public cloud systems are still the most common. And so our research found that there are 3 key associated risks for education systems that are becoming increasingly cloud-based, such as Uruguay's. And the first is re-identification. So current systems generally don't protect students' data from being re-identified. So personal identifying information used when a student, for example, registers for a course on one of these systems is not scrubbed or removed, which means that students' data can potentially be used by these third-party providers for purposes other than which they have given consent. The second is the practical impossibility of real informed consent. So you've probably heard of this concept of free, prior, and informed consent, or FPIC. And despite the fact that Uruguayan law affirms this principle with regards to personal data, the complex ways in which student data is mined, amalgamated, and used is honestly probably too complicated for the average student or their parent or guardian to understand. And so there's a risk that free, prior, and informed consent to the disclosure, storage, or use of personal information in these systems is really not possible. And finally is the practical inability to opt out. So even if students and or their parents do not want their information to be collected and used by public clouds, there might not be an alternative if they wish for those children to remain enrolled in that school system. So in other words, if the use of such platforms and therefore the consent to data collection is required by a school system, this may make it de facto impossible to opt out. Next slide, please. So how does this all relate to Plan CBAL and Google? So in May of 2015, Plan CBAL and Google finalized an agreement to make the full suite of Google Apps for Education tools, so email, Google Slides, Google Sheets, Google Docs, all of these things available to all teachers and students of public and private Uruguayan education. So while at first glance, this might seem great, there were some substantial concerns raised surrounding the ambiguity of the agreement, whether users had a choice as to whether to consent to Google collecting their personal data, even for these education purposes, and concerns of this nature. And so around this time, an open letter from a monthly newsletter team called Digital Rights Slack, or Latin America and the Caribbean, highlighted their many concerns with the agreement, one of which being that personal information of students and teachers would not only be stored on servers outside of the government's control, but outside of the country itself. So this kind of goes back to the concept of the public cloud system that we just discussed. And they also make a pretty bold statement that any claims about the acceptance of Google Apps for Education's terms and conditions being voluntary was a, quote, fallacy. So this letter was pretty strongly worded and circulated widely nationally as well as internationally. And perhaps in response to this, Plan CBAL added information onto its website detailing the terms and conditions that you must accept when you create an account, as well as relevant resolutions from AGESEC and other entities that approved the transfer of Uruguayan students' data to Google for the purposes found in the agreement. However, according to a timestamp on the website, this information seems to have been added or at least updated in November of 2019. So this is more than 4 years after the agreement between Google and Plan CBAL went into effect. So it is therefore not clear how widely disseminated and easily accessible this information was to the general public before that date. And based on this open letter, it can be assumed that both the terms and conditions users would have to accept and the relevant resolutions and clarity needed to make their decision was not made conspicuously available at the time the agreement was solidified. Next slide, please. So the bottom line is this: does this agreement represent free, prior, and informed consent? That is a really difficult phrase to say. I would recommend you practice it. Free and consent, not really, because if all students and teachers in Uruguay, or at least those in the public school system, are required to use the Google Apps for Education tools, then this isn't really free. And based on available information, it seems like the only alternative for parents, other than their child dropping out of school, which really isn't a viable alternative, would be to enroll their children in a private school, which, in addition to the potential financial barriers posed by private school tuition, it does seem that private schools may also be using these tools as well. It was difficult for us to confirm. So yeah, not really a viable option there. Prior consent, again, it's unclear but unlikely based on the conversation of the letter that was circulated by Digital Rights Slack. It does not seem that this information was available as the agreement was being finalized and before parents and students and teachers had to offer their consent. Informed, yes, definitely. This FAQ list on Plain CBOL's website is extensive, and it spells out all the terms and conditions as well as how users' data will be used very clearly and in a way that is easily understood by people who maybe don't have a background in this area. And finally, it's just worth mentioning the interesting terms of this agreement in which Google agreed to provide its many services to Uruguay without any cost to the state or its users. And since, according to this agreement, Google does not derive any monetary compensation or the ability to utilize users' data for its own research and marketing purposes, or get any other apparent benefit, it is surprising that Google would engage in such a contract. So it does raise question as to whether there could potentially be benefits that weren't publicly disclosed in the agreement. But ultimately, there are many potential risks associated with cloud computing, including the ability to build user profiles with years of data and target students for unsolicited advertising, among other things. It is therefore crucial that potential users have the ability to make an informed decision about whether to participate in tools such as Google Apps for Education without their right to education being significantly hindered. And now I will hand it off to my colleagues on the government surveillance team so that they can discuss the findings from their research.
Great, thank you, Natalie. So I'm just going to outline governing law in court cases before passing it on to my colleagues Kangdi and Akanksha, who will discuss relevant cases that have developed in the past few years. So first, I'd like to discuss a few articles in the Uruguayan Constitution that protect individuals' rights to privacy generally, and more narrowly against improper or excessive government surveillance. So the first is Article 7, which states that residents of Uruguay have the right to protection in the enjoyment of life, honor, liberty, security, labor, and property, and that this right can only be limited by laws enacted for, in quotes, reasons of general interest. Article 11 more directly addresses the right to privacy within one's own home, as it states that the sanctity of the home is inviolable, adding that no one may enter without the order of a competent judge in writing and in cases determined by law. Article 28 discusses the privacy of documents and correspondence, declaring that the papers of individuals and their correspondence are inviolable. Government entities, including law enforcement, may only search or intercept correspondence in accordance with laws of general interest, which is, again, the same limitation established by Article 7 in discussion to individuals' right to privacy in their own property. Article 72 states that the rights included in the Constitution are not exhaustive, so there are additional rights that derive from a republican form of government or which are inherent to human beings that also exist, while Article 332 states that the rights enshrined in the Constitution shall not be without effect by reason of a lack of corresponding regulation. With regards to statutory law, there's two main foundational pieces of legislation that outline government surveillance. The first is Article 205 of the newest Criminal Procedure Code, CPP, and the second is Article 146.2 of the General Procedure Code, as well as several other more narrow pieces of legislation. So the Criminal Procedure Code, CPP, was approved in December of 2014 by law 19,293, and it entered into force in 2017. Importantly, according to Article 205, the Public Prosecutor's Office has the power to request authority from a competent court for the interception, seizure, and subsequent opening or recording of any correspondence sent by or to someone accused of a crime. Section 1 states that this provision applies to electronic mail or similar, and this has since been used to wiretap effectively. Section 3 further states that third parties may also be subject to this law if the judge has well-founded reasons that such communications could serve as evidence for their participation in the crime. The General Procedure Code was passed by the General Assembly in 2013, replacing some of the articles in its predecessor.
Article 146.2 states that any sources of evidence not explicitly prohibited by the rule of law may be employed in criminal prosecutions, provided that the use and collection of such evidence complies with existing restrictions. There's a few other laws that further discuss personal privacy as it relates to wiretapping and also government databases. So the first is Law 18,331, which some of my colleagues have already discussed. Article 1 states that the right to the protection of personal data is inherent to any human person. Importantly, Chapter 5 focuses on publicly owned databases, and Article 25 holds that law enforcement agencies and other government entities may use and store personal data without the consent of its owner, but only if such data is necessary for the strict fulfillment of missions relating to national defense, public security, or crime suppression. Article 26 adds that personal data does not need to be erased if it is necessary for the investigations for which they were created. Further adding that that such data will not be deleted if it would compromise the defense of the state or public safety. An important law is Law 18,494, which is on the control and prevention of money laundering and terrorism financing, and more narrowly, Article 5 of this law. This law is no longer enforced, but it was used by authorities to wiretap in the investigation of certain crimes. It stated that in the investigation of any crime, all available technological means may be used, so long as the execution of government surveillance is ordered by a judge at the request of the prosecutor's office. This law was repealed by Law 19,574, which created a broader government unit for fighting such crimes, but still Law 18,494 is important as it was used for wiretapping for a period of time. There's two important cases that I would like to focus on. If you could go to the next slide, please. So the first is Supreme Court Case 58 from 2009. And the second is case number 377 before the Second Court of Criminal Appeals in 2013. So in the Supreme Court case, the defendant argued that the predecessor to Article 205 of CPP violated Articles 7, 28, and 29 of the Constitution. He claimed that wiretapping infringed his rights to privacy, freedom of expression, and the protection and the enjoyment of life, honor, liberty, security, labor, and property, as is guaranteed by Article 7. The court found that while Article 205 of CPP might lead to the lack of protection and the enjoyment of some of the rights included in the Constitution, these rights are limited by laws adopted for reasons of general interest. Because the verification of a crime is a reason of general interest, therefore, wiretapping does not inherently violate the Constitution as long as it is subject to judicial control. Case number 377 of 2013 before the Second Court of Criminal Appeals further added some potential restrictions to wiretapping. In this case, the defendant was accused of transporting drugs through an illicit organization, as well as drug trafficking and financing, and so he was subject to Law 18,494. In this case, the defendant argued that his conviction should be annulled for 3 points, that the GPS data used by law enforcement was incorrect, that a search of his yacht was conducted without his consent, and finally, that wiretapping violated his constitutional right. The court pretty summarily dismissed his first two submissions. It held that the search of his yacht was carried out with irreproachable legality, as it was authorized by a search warrant from a judge, and it further held that the GPS data was indeed correct, and that even if it were not correct, the rest of the evidence was sufficient to convict him. The most important part of this case, or the most interesting part perhaps, was that although Article 5 of Law 18,494 provided that all available techniques could be used in prosecuting, in quotes, all crimes, there should be some limits to this power. The court held that while wiretapping could serve as la reina de las pruebas, or the queen of evidence, if it were used in all cases, it would turn Uruguay into, in quotes, a surveillance state. And so the court held that there should be some limits to the policy, but it did not set clear boundaries for such limits. Indeed, in this case, there were some 2 tons of cocaine in question. So that certainly is a high threshold if that's what was implied, but it seems that the judge believes that the burden should be far lower. Thus far, there haven't been very many complaints about the law, but there are potential issues with authorizing wiretapping for the prosecution of all laws as was permitted by this law. So with that, I'll pass it on to Kangdi, who will discuss some other cases.
Hi, in this section, we will give some illustrative examples of how government surveillance are conducted and supervised in Uruguay. Next slide, please. First, what granted the government the power to have government surveillance actions? In Uruguay, the major conductor of government surveillance is the National Police, governed by the Ministry of the Interior. For the data collection, the law 18315, or the Police Procedural Law, in Article 223 stipulates that the police can legally have observation and deterrence actions, which means passive and active surveillances. Furthermore, in Article 31 BIS, the law stipulates that police actions are assumed to be legitimate unless proven otherwise, which means unless there are other laws stipulating that those shall not, police surveillance actions would be assumed to be legitimate. And there are certain limitations, as Alex just mentioned, specifically for surveillance towards private correspondence and in closed spaces and in buildings. Next slide, please. Next slide. Just stay on this. Thank you. As for the data processing and storage, also as we just discussed, the data protection law, Article 3 stipulates that databases established for public security or relevant reasons, they are not governed by this law. So government surveillance databases fall within this category and are not safeguarded by the data protection law, thus need not to be open for the public to access. And the General Procedure Code stipulates that these data collected, as long as they're collected in a way, as we discussed, court-authorized way, they can be used as criminal prosecution evidences. Next slide, please. Let's look at some concrete examples. CCTV cameras deployed by the police on Montevideo streets. The deployment does not involve surveillance of any private correspondence, and they are in open spaces. So the police do not need to ask the prosecution or the court for an authorization to deploy a camera on the street, nor do they need to ask passengers for consent to record their motions on the cameras. And the databases for these cameras, because they're established specifically for public security purposes, they're not safeguarded by the data protection law. The National Police of Uruguay believe that surveillance devices are indispensable weapons to fight crimes, especially considering that, according to the Ministry of the Interior, that from 2016 to 19, the homicide and armed robbery rates in Montevideo were increasing. And the major cooperator with Uruguay on this is China, a country renowned for its mature surveillance technologies. Since 2008, China has been supplying public monitoring spots, border control cameras, and urban security monitoring centers that connect all CCTV cameras in one place to Uruguay. Next slide, please. These devices turn out to be very effective and cost efficient. According to a study by the scholars from University of Montevideo and University of San Andres, these deployed cameras can on average reduce crimes in deployed places by 20%, and they only cost about 1/5 of the estimated total expenditure that could have been incurred without the cameras. Next slide, please. And as for the surveillance in private communications, as we just discussed, for surveillance actions towards private correspondence, buildings or other places to the prosecution for evaluation, then the prosecution will send it to the court for final authorization. Only after these two steps can police take surveillance actions of these targets or in these places. And next, my colleague Akanksha will give us a case study introduction of The Guardian, a surveillance system purchased by the Ministry of the Interior in 2013 towards private correspondence. Let's welcome Akanksha.
Hi, so I will be looking at El Guardian, the surveillance system. As Kandi mentioned, it was purchased by the Ministry of Interior. To start off with, it is actually a system that was developed by a private Brazilian technology company, which centralizes and streamlines the operation of well over 20 interception programs that have been operating alongside each other, but not collectively. The purchase was made in 2013, and it was not publicly disclosed. It has also been very costly. At that point, the purchase itself was $2 million, with an additional $200,000 annual maintenance cost alone. This system actually allows the government to intercept calls and other data traffic from about 800 cell phone lines, 200 landlines, and about 100 email services. That is just the basic, including monitoring the social media in real time. The three major telecommunications company in Uruguay, which are Carlo, Movistar, and Entel, were also obliged to deploy the corresponding complementary equipment to grant the system direct access to their information to follow the protocol that had been put in place by the Ministry of Interior. Because this purchase was done secretly, the public security safeguard purpose became a domestic security issue. It was withheld from the public, and it was only revealed to the Uruguayan citizens, was not even through the Ministry of Interior, but through a newspaper called El Pasi. The government has been using El Guardian since 2014, which came with its own set of issues that was limited transparency around how the system operates. Additionally, the public and legislative oversight of the systems that were not effectively in place either. It also further shows a public lack of access to guidelines and governing state access to telephone and internet data. During its appearance before Parliament, which was due to the non-disclosed purchase of the government of non-disclosed purchase of El Guardian from the Ministry of Interior, it was questioned whether it was legitimate or not. And according to Article 5 of Law 18,494, it was for crime investigative purposes, and it also claimed that all the collected information would be kept safely in a highly advanced center. The Supreme Court confirmed the legality of the system based on Article 205 of the CPP. They also said they carried under the judicial supervision, if a police officer who wants to intercept a wiretap using this system must first submit a formal request to a prosecutor for evaluation, and only then the prosecutor must submit it to the judge for a formal approval. Despite the Supreme Court's confirmation, the purchase and the deployment of these mechanisms of surveillance of private communication without disclosure has been an issue. It has data processing procedures that raise civil society's privacy concerns, generating even more doubts with with the Ministry of Interior statement, during which it was then found out that there were 22 similar systems already operating in Uruguay with no oversight prior to the purchase of the El Guardian. The executive director of the Center of Archives and Access of Public Information also was concerned with privacy issues and submitted a request in 2015 to the Ministry of Interior seeking to make more information public, but they did not get any response, and therefore they filed a lawsuit based on the law governing access to public information, which is Article 18 of Law 18,000, sorry. The suit was dismissed by both the Administrative Court and the Court of Appeals on the grounds that the purchase of El Guardian and the details of its technical characteristics could be lawfully kept as a secret from the public for security reasons. The Court of Appeal emphasized that the strength and the weaknesses of the Guardian were disclosed to the public, and it might leave the system vulnerable to hackers if disclosed. We also talk about the Ministry of Interior also developed a computer tool, which is Sistema, I am so sorry, I will not be able to pronounce this correctly, so we'll go with SAIL, to assist the judicial branch in supervising the police's private communication surveillance actions. It permits the prosecutors and the judges to track the processing of any interceptions that was made by El Guardian before, during, or after its completion. The sales tracking record page demonstrated by the Ministry of Interior this is what it actually looks like. It was in 2017 that the Ministry of Interior requested the Ministry of Economy and Finance to audit all the information that had been intercepted by El Guardian. The audit concluded that all the interceptions had been authorized by a judicial order following a police investigation. It was then in 2019 that they published a general working procedure for El Guardian's lawful telephone interference and any other interference made on any social media or digital platform. Now I would like to hand it over back to Kandi to go over the conclusions of this section.
Therefore, according to our research, so far we have found no substantial evidence showing that there is any surveillance overreach by the Uruguayan government yet. But as we've discussed in the case study of the Guardian, the transparency concerns still exist because we, the public, does not know what are the criteria for prosecutors and judges to evaluate a necessary wiretapping. And we also do not know how to ensure that the data centers storing all the information collected are safe. However, because the court believed that if releasing such information could give advantage to the hackers and making them more easier to break into the databases or the whole wiretapping process, so the court decided that it should not be released. But the transparency concerns still remains, and it is an issue that the civil society should keep paying attention to. Thank you.
Hello. So given the importance of COVID-19, since you're all on Zoom, you're already aware of that, we would like to talk about how this specific issue has impacted data privacy, because the nature of an illness requires a significant amount of tracking in order to determine where the spreading is going and how to effectively respond to that. This, of course, has raised a lot of issues and debate regarding how COVID-19 could have impacted the data privacy rights and general privacy within the country. Next slide, please. But first we need to go discuss the very nature of how COVID is in Uruguay. Uruguay is best split into two different phases of this. We would call it the pre-surge and the post-surge period. As you can see with the graph, the first several months of COVID-19 in Uruguay were well handled. The first cases began in March of 2020. These were small isolated cases brought forth by travelers from Italy. The government mounted an effective response on that initially. It closed schools. It shifted things online as much as it could. It put in restrictions, same as many other states and countries, and it effectively managed that for the first few months. Helping this as well was the fact that the start of COVID-19 was the general winter within the country with reduced activity. However, Uruguay began to suffer what a famed virologist of the country called a victim of our own success, where due to the well-managed response of the first few months, the country and the population took it. The country and the population were rather lax on how they handled COVID-19. And as a result of that, as you can see, starting in late November and into December, the first real wave begins. This then steadied down, but this then rapidly increased due to higher general activity, proximity towards the new variant strains happening in Brazil, and the general exhaustion of lockdown conditions. The silver lining in all this is, however, is that the vaccine rollout begins in early March of this year, with the government prioritizing the essential workers, obviously frontline medics, teachers, and so on. And Lei has been pushing to later expand this. This is all happening concurrently with the biggest bottleneck being the delivery of the vaccines, as Uruguay lacks, unfortunately, the pharmaceutical capacity to manufacture most of these. Next slide, please.
Thank you, Ibrahim. So with our research into Uruguay's response to COVID-19, I wanted to focus on a few key elements of the government response. On April 8th, 2020, the departmental and municipal elections, which were scheduled for the following month, were actually postponed until September 27th, 2020, with the enactment of Law 19,875. This law required a special majority from the General Assembly due to its constitutional ramifications, namely postponing elections required by Article 77 of the Constitution due to the inability to guarantee the holding of these municipal elections in May. Obviously, the postponing of these elections marked a not insignificant display of government intervention in the democratic process. The current administration, however, addressed the public and explained it did not wish to be seen as authoritarian. The wording of Article 2 in Law 19,875 stated that such power to postpone elections would be extended in this case and only once, and I quote, emphasizing that such influence over the election cycle was to be considered exceptional given the state of a national health emergency and not to become a precedent. In addition, as far as the creation of the health policy team to advise the president, the government actively incorporated scientific and public health expertise to develop its response to the crisis. An advisory council of experts named the Honorary Scientific Advisory Group, or in Spanish, El Grupo Asesor Científico Honorario, abbreviated as GACH, was established on April 16th, 2020 to provide health policy recommendations directly to the president. It is led by Coordinator General Dr. Rafael Radi, with research and recommendations from the council having been made available on an ongoing basis for public access on the Office of the Presidency's website. This group's role to the presidency sort of resembles the status of the Center for Disease Control in the US, meaning that they inform the public and the government on recommendations concerning matters like interactions in schools, holiday celebrations, and remote work, while also conducting research on COVID-19 related health topics and prevention strategies. Finally, misinformation was one key topic that actually came up quite a bit in assessing Uruguay's early response to the pandemic. At the time, shortly after March 2020, misinformation related to the virus was widely disseminated via social media and word of mouth, prompting several initiatives from various stakeholders to combat the issue. the United Nations Development Program Office in Uruguay and UNESCO both teamed up to develop a joint digital awareness campaign. This partnership produced a series of animated videos to educate the public, more specifically youth and children, on the spread of false information online. These videos were actually translated into 6 languages, including, in addition to Spanish, English, Portuguese, and Quechua. As another initiative, a training course was offered for journalists to better discern verified versus erroneous information in their reporting. This campaign additionally reported on public health responses to prior pandemics and the effects of misinformation on election outcomes. And finally, raising awareness to issues of misinformation engendered support across party lines. This is something that seems relatively unique to Uruguay, especially in comparison to the US and other countries. Recognizing the vulnerability of democratic institutions to the spread of misinformation and false claims, the Uruguayan Press Association, or the UPA, with the support of the UNDP, sponsored the renewal of a signed commitment against misinformation by all active political parties in Uruguay. That's right, all active political parties with representation in the General Assembly signed on to this. Although the original pact had been signed in 2019, well ahead of the presidential and parliamentary elections, let alone COVID, it was resigned and reinforced a year later during COVID, meant to encompass elections at the local and regional levels. This reaffirmed commitment across all political parties in Uruguay demonstrated a pretty strong sense of shared responsibility in responding to the pandemic and promoted unbiased reporting in both political and public health spaces. And I'm going to turn it over to my colleague, Matt.
Thank you, Alex. So I will be talking about coronavirus UI. Again, it is Uruguay's one-stop shop for resources and news for the coronavirus in Uruguay. It was developed with the mind of avoiding the collapse of the health system and unnecessary contact with possibly infected persons. So before I kind of dive into the application itself, I'm first going to talk about the legal foundation for the application, which is the Telemedicine Act. And essentially what the Telemedicine Act did was extend the right to privacy for in-person medical visits, so doctor, hospital, to the digital sphere, so Zoom, Skype, or even over the application. So the app itself has a number of qualities. The first of which is its expedited development. It was developed, or its first version was developed only 7 days after the initial outbreak. And additionally, it was a private and public partnership between the Uruguayan government and nearly 30 private companies to develop this app. Some of the more prominent actors in that partnership was Genexus and Google and Apple. So some of the features of this application are the exposure notification feature, which was in fact developed by Google and Apple. The telecommunication with health professionals was made possible. Additionally, vaccination verification, negative testing documentation through QR codes. And then lastly, news updates about possible new legislation and updated numbers on the coronavirus itself. Lastly, to give you an idea of the spread of the application within Uruguay, there were nearly 1.26 million downloads after the first year, which is roughly a third of Uruguay's population. And then after the uptick in cases in April, there were an additional 200,000 downloads in Uruguay. So to talk a bit about public response to this application, there are, my understanding, 2 schools of thought, but are not necessarily independent of one another. The first is this great pride of Uruguay being able to respond very quickly to this, the COVID pandemic with this application. And then in addition, the ability of the government to collaborate with many private entities to develop this application so very quickly. However, there were some nerves after its development. Chiefly was its quick development. There were concerns about maybe holes in privacy rights and privacy for individuals. And then additionally, the involvement with Google and Apple. And as many have read, there are issues with Google and Apple in data privacy. So this will lead me into the implications on privacy. And with our research, we found that some of these concerns about the application were somewhat misplaced, and I have 3 reasons for that. The first of which is the technology itself being used with the exposure notification system. So as many of us think of location tracking, this was not the technology used. So the technology was not using a GPS type system. Instead, it was using Bluetooth proximity technology. So instead, it was only noting when the 2 phones, which were emitting Bluetooth, were in close proximity to one another. Second was there was actually no data stored in Google nor Apple servers. All of this data was stored in the Public Health Ministry servers. So the security concern should not be, if there is a concern, would not be with Google nor Apple, it would be with the Public Health Ministry. And then lastly, it is in fact an opt-in system. So Uruguayans are not, when they download the application, are not automatically signed up for the notification or exposure notification feature. So they would have to go into the system and opt into it. So what does this mean moving forward out of the pandemic? After speaking with HSIC and Genexus, there are hopes that this application is turned into not just a one-stop shop for coronavirus itself, but as a medical platform for people to engage with the medical field from distance, whether that be due to being sick or inability to transport themselves to a medical facility. So moving forward, we hope that as these digital technologies advance, so will the underlying legislation and foundation for the law and the carrying out of that law. And with that, I will hand it over to Natalie for concluding remarks.
Thanks, Matt. So next slide, please. As we close out our time together, we just wanted to share some kind of overarching comments about each of the topics that we have discussed today. So one major takeaway from our research that applies almost across the board is that Uruguay has been a leader in its adherence to human rights instruments, both global and regional. It's recognized the importance of the institutionalized protection of personal and data privacy in an age in which we rely increasingly on technology in all aspects of our lives. And each subgroup also has, to a certain degree, identified the inherent difficulty in balancing the right to privacy and a state's need to maintain order, to prevent and address criminal conduct, and to defend itself. That said, privacy is a critical element of personal integrity and an internationally acknowledged fundamental human right. So while finding the balance between maintaining a respect for the rights of individuals to pursue their own lives without unnecessary intrusion and allowing the government to act in the interest of its citizenry as a whole is an enormously complex and difficult task, we believe that it is one worth pursuing. Along similar lines, another common thing that we observed is that the law protecting privacy can really only go so far in reassuring citizens that there are areas in which they have the right to be left alone. So this is why the mutual trust between citizens and their government is critical. Next slide. Thanks. The bottom line is this: as long as people believe that the government and its agents are acting in good faith and are motivated by a desire to protect privacy, even while seeking efficiency in promoting public safety, the discussions on how exactly to go about achieving these goals will be open and productive. And based on our observations, this degree of trust and willingness to dialogue does seem to be present in Uruguay. Additionally, technology has put enormously powerful tools into the hands of governments and giant companies. And it is vital to the future of democracy, not just in Uruguay, but in any other country, that the use of these tools be decided by the people. And moreover, citizens must be supplied with the requisite information needed to make wise choices about these issues. And by all of our research, Uruguay appears to be well aware of the opportunities and the dangers to privacy that are inherent in this digital age in which we live, and they're actively confronting them. Next slide, please. Finally, we just want to say thank you to the many Uruguayans with whom we've had the opportunity to speak with and learn from over the course of this year. And I think I speak for everyone when we say we would have loved to engage with you in person, but the willingness of so many to support us to introduce us to other connections, and really just to ensure that we had all of the material that we needed to make this project a success is incredibly appreciated. And so the members of this clinic would also just like to offer our solidarity with Uruguay and its citizens as they confront and defeat COVID-19. And we wish them a speedy and complete recovery in all aspects. So thank you so much for everyone for your attention and your attendance. And we'd now like to open up the floor to Q&A. I'll hand it back over to Professor Schneebaum to facilitate.
Well, thank you, Natalie, and thanks to all of you. I hope that most of our viewers are still with us. We've covered an enormous amount of material, and I dare say we've covered it, I think, in exceptional detail. The students have, as you can tell, worked exceptionally hard during this difficult year of having to conduct all of their research, all of their conversations, all of their interviews, all of their analysis, not only remotely as between themselves and Uruguay, but remotely even amongst themselves. That is, they have not been able to be in the same room to discuss their research and to discuss their findings. I think they've done a remarkable job, all of them, and I'm very, very proud of all 12 of the students who have participated this year in the International Human Rights Law Clinic at SAIS. Now let me open the floor for questions. There haven't been any posted during the discussion, but I hope we'll be collecting some. I have one or two if no one else does, but I see there is a question here from Professor Gardner, in fact, who asks about the education program, the one that Natalie Smith described, the Google education program, and the extent to which civil society and civil society organizations have been coordinating with international watchdog groups to keep tabs on that kind of operation. What do we know about that, Natalie?
Yes, thank you, Professor Gardner, for that question. So kind of one of the things more broadly as a data privacy group that we encountered based on our conversations with civil society actors was that the space, the civil society space and the actors engaging in data privacy related issues in Uruguay is pretty small and pretty niche. So in general, because as we've discussed today, I mean, Uruguay has an incredibly robust protection, legal protection of data privacy issues, it doesn't seem like there are a ton of actors working on that space. So in terms of international presence in watchdog organizations, we didn't come across anything in particular. It seems that most of the conversations and concerns surrounding this agreement were kind of quelled after a year or two. So that took place in 2015. And it seemed by 2016, 2017, the conversation had died down a bit. But again, there are whispers on the internet that we could find of just, hey, what is the status of this? I mean, are we regulating Google in any way? And one interesting thing I found actually in our research that we didn't get to touch on was kind of supplemental documentation on this agreement, where basically it says that the user, so Plain Seaball, has the right to audit or request an audit of Google and how it's using data if it's under European data protection, legal protection. And so we're just kind of wondering, could this be a potential loophole? Because while Uruguay models its data privacy regime, legal regime based off of GDPR standards, it gets a gold star in all of those areas. It's unclear to whether they would also be granted that right to request an audit of how Google is using these tools. So yeah, it just seems like there's not a lot of civil society discussion, watchdog organizations really engaging in this issue. And it doesn't seem to be overtly causing damage at this point, but just something to keep on the radar for the future.
Thanks, Natalie. Now, you know, we've tried very hard, and perhaps all of the viewers and listeners will have perceived this. We've tried very hard to avoid making judgments. It's not our job, after all. It's not our role. It would be presumptuous for us, for any group of foreigners, students, to be passing judgment on whether Uruguay is meeting its international obligations or not. We've simply reported the facts as we found them and reported the legal basis as we found it. And of course, people need to make their own decisions about that. But let me ask perhaps a quick answer from each of the four subgroups on this. There have been throughout the presentation some red flags that have gone up. Each of the groups suggested that there were areas that were of potential concern. In the personal privacy area, for example, the issue of the need for consultation and a 5-day waiting period for a woman who wants an abortion. It certainly looks as if that could be used as a way of attempting to persuade women not to have abortions, to influence their choices. In the data privacy group, we heard about how, well, the education software program that Natalie was just talking about raises some concerns. The increased power of the tax authority to investigate people's finances raises some concerns, and the use of the budget process, the budget legislation process that fast tracks bills that might contain significant developments with respect to privacy rights. In the case of surveillance, we heard some concerns about the 22 systems, unidentified as far as anyone knows, that were in use in Uruguay even before El Guardian was purchased, and then of course the potential for the abuse of El Guardian. And finally, although the coronavirus team reported that there were no particular worries about coronavirus UI, it's doing its job well, the possibility of these kinds of software packages being used for, shall we say, less benign purposes still exists. So what is our advice to the people of Uruguay with respect to ensuring that this respect for privacy rights as internationally protected is actually maintained in the future? What do we all think about that?
Should we maybe go in order, Professor? Start with personal privacy group?
Sure, let's have somebody from personal privacy first. Who wants to take that one on?
I guess I don't mind taking this one from personal privacy. While we do have concerns that Professor Schneebaum mentioned, both the ones on the waiting period and also the ones that Professor Gardner mentioned on the unlimited nature of conscientious objections, in terms of going forward and improving not just this, but also in other spheres, one thing I would like to point out is that Uruguay does, in their transition from military rule to its current system, they do have a history of interacting with these systems and evaluating where their law is and how it's harming folks. So while I do think it would be presumptuous to say Uruguay needs X or Y system to self-actualize, for lack of a better word, the current tradition Uruguayan civil society has of driving their own government forward, ever since the transition of democratic rule, of military rule, does seem to be functional and does seem to be doing a lot of good for the country.
Faraz, perhaps, on data privacy?
Yes, absolutely. So I think going back to what Professor Schneebaum said, it is absolutely not our place to judge. And actually that was specifically for the data privacy group, that was very convenient because, as we mentioned before, the data privacy regime in Uruguay is so robust, not just, regionally speaking, but internationally speaking. They are one of the best protectors of data in the world. So for us, specifically looking at our case studies, it was honestly difficult at some times to find something that would be relevant, interesting, and not just nitpicking, And I think the case studies that we flagged, the three of them, the financial data protections, the budget law process, and the education digitization, I think those case studies show that even when Uruguay is really committing to promoting data privacy, it's almost impossible for a regime to be perfect. And while this is an exceptional regime, there are a few areas where not necessarily even problems may arise, but there are potential for where the statutes do not exactly legislate away the potential for abuse. And that was honestly the worst that we could find about it. So if anything, again, it is the opposite of an indictment on the Uruguayan data protection regime.
Good, thank you for that. Perhaps Alex Mejia, would you want to take on the question of whether there should be greater concern about surveillance or the right amount of concern?
I think, Professor, that question falls within my part more generally. So for the 22 previously unknown surveillance systems question first, technically speaking, at least they are now no longer a problem because they have all been integrated into the Guardian, into one. And as we just presented, the Guardian, we do have the sales system, at least for the prosecutors to track every request sent for evaluation. But if you're asking us the value judgment questions, and I am bold enough to give my personal, just personal, not even group, just personal opinion on this. As someone who comes from a country renowned for wide use and mature use of surveillance technology, China, I would say that the use of this sort of known or some unknown surveillance system could be a necessary evil for every government in this world, whether it's in China or in countries like Uruguay and the United States, whose surveillance and privacy regulations are more robust. The governments always need, just as the courts in refuting the request to open more information to the public, always need to have some sort of hidden weapons in their pockets. And as long as we do have what Uruguay now have, the laws regulating them, and we know that there is such a system, we could rest relatively safer than in situations without them. Because just like what happened in the United States for the PRISM project, before it was revealed by the newspapers, no one knew that there was such a system. And the glad thing we're seeing Uruguay is doing that after that the Guardian has been revealed by the newspaper, the Ministry of the Interior and the courts, they are both reacting very actively to answer those questions raised by like Kingfo about their privacy violation concerns. And I would say that is a good sign. And in practical terms, it is simply not feasible, although we would want to, but I think it is not feasible for us to request government to reveal everything about technical details and criteria. But what I think could be done in the future is that at least for the prosecution and the court's parts, they could release more details on the more general criteria, like what is the necessity criteria for determining when we need a wiretapping. Give us some examples. And to that degree, I think that's something that the Uruguayan government and the legal system could do in the future.
Oh, thanks for that. Matt, let's just close this part out. Are you confident that coronavirus UI, which you described in such glowing terms, will not cause any negative effects after the virus is over? I mean, it could be misused in the future.
Definitely. And kind of mirroring somewhat of what Kongi said is anytime you have, and especially in our world with rapidly advancing technology, the people putting it out there, I think they don't even know its true capabilities. So when it comes to transforming coronavirus UI into something a bit more broad in spectrum, I think it is required to make it more robust, the further implementation of new technologies. And as long as Uruguay continues to have a private first methodology in implementing these two technologies, I would hope there are no further problems. But I think the problems could come with adopting technologies like the Googles and the Apples in the world who have such resources to develop such cutting edge technologies to be implemented into a system like what coronavirus UI could become is where the danger could happen. But through my research, it seemed that ministries like the Public Health Ministry and offshoots like HSIC were so concerned with providing no personalized data to any of these private entities. So as long as that is continued and the Uruguayan government continue their hold of personal data, there will hopefully not be any breaches.
Thank you. Thanks very much for that. And thanks again to the class, of course. What a magnificent job they've done in very, very difficult circumstances. But it's also appropriate, I think, not only to thank our viewers and listeners, but to give a particular shout out to the best helpers we had, who were the personnel of the Uruguayan embassy here in Washington, D.C. And especially thanks to Ambassador Andres Duran and to our guide in all things Uruguayan, Francia Grignoli. Thank you very much to the two of you. Let me remind viewers and listeners that the report that you have just heard summarized, which is 150 pages long, there's a lot in that report that you did not hear about just now, but the report will be available, we are told, on or about June 4th, and we will circulate electronic copies of it to the invitation list to this webinar. So therefore, if you're still with us, you'll be getting a copy. If you're not on the list and you would like one, or if you know someone who would like one, please send me, I guess, or one of us, an email giving us email addresses to which we can send the report in early June, and we will be very happy to do that. This webinar has also been recorded, and when we circulate the report, we will also circulate a link to the YouTube video that you can watch at your leisure or share or pass along to anyone that you think might be interested. Thank you again to all. Thanks to the class for this phenomenal job. And thanks to all of our helpers, all of our friends. And I at least hope to see everyone next year when the next year's International Human Rights Law Clinic reports on a different set of human rights issues in a different country. We don't know what those are going to be yet, but watch this space and stay tuned. Thanks to everyone. Thanks for tuning in. Bye-bye.